A follow-up to both of these points. I think we all can agree that the wireless and broadband industries have enjoyed an explosion, a revolution, an innovation that we've all really benefited from. But if these services are critical and wireless is a substitute for telephone, how do we ensure that that there is coverage in the spotty or unserved areas for cell service if there's no assertion of jurisdiction? How do you balance the innovation with the need for access?
I'm not sure I agree with the position that criticality is somehow a sufficient basis for litigation. Water is critical, food is critical, clothing is critical, but they're all sold in competitive markets. The market mechanisms, I think, and I guess I'm going to reveal my philosophical biases here. The market mechanism has worked very well in bringing the U.S. economy to where it is today. Certainly the economy is having its problems, but they really shouldn't blind us to the tremendous accomplishments that have been made over the years and decades and centuries. And regulation should be a response not to the criticality of services, but to market failures. I don't think we've seen anything in the wireless space yet that constitutes the kind of pervasive market failure that would warrant a regulatory response. It's not to say there haven't been some problems. It's not to say that consumers haven't had complaints, some of which, some proportion of which are certainly legitimate, but there are mechanisms to deal with that. And to say that merely because of that situation, merely because of the potential for problems, we need to have a regulation is, I think, a dangerous assumption to make. And I don't use the word dangerous lightly. I think it's easy to fall into the habit of saying, gee, why wait until problems exist? Why don't we put a mechanism in place to deal with them in advance? But there is a depressing effect to regulation. I'm not an economist. I can't speak to the empirical data. But you know, in the 2 decades I've been practicing regulatory law, I've had a chance to observe its operations. I understand and appreciate the areas in which it may be necessary. But also, I've had a chance to observe the impacts it can have on businesses and the impact it can have on focus. I honestly do not believe, and you know, this is as much a matter of philosophy as of empirical data, although I believe it's supported by empirical data, that more regulation is necessarily better and that it's necessarily risk-free. We need surgical regulation that acts only where it's necessary and appropriate.
Joe, let me challenge you just a little bit. You mentioned surgical regulation, and I think, you know, the question we're trying to get at is that the department staff, at least, has expressed a desire for some minimum set of regulatory principles in the study, or the assessment, I should say, which Karen laid out earlier: basic consumer protections, affordability, equitable contributions to public funding, emergency response and restoration. So, you know, from my perspective anyway, I think that is a relatively light touch. So what I would like to challenge you on a little bit is to tell us where that line would be. If the commission were to go ahead and institute a proceeding to reassert jurisdiction over wireless in a hypothetical scenario, what would the bright line be where it would become depressing investment versus ensuring that New York consumers are being protected and are being given information and have a forum for complaints, et cetera?
Well, I think that's the problem. I don't know that you can draw a bright line saying let's regulate this, not the other, because once the line starts moving, there's a natural inertia that tends to keep it moving until you have a fairly comprehensive regulatory environment. Some of the areas that you mentioned, I think, are adequately dealt with by the market. Some of them are adequately dealt with by existing federal regulation. Some of them are adequately dealt with by non-regulatory legal restraints. Emergency response, which I think is genuinely an important issue. I think staff and the commission have done rather well in soliciting and obtaining the voluntary cooperation, not only of the wireless industry, but of other unregulated industries.
May I speak to this? I think emergency response really hits on a key aspect of this, because emergency response only really works if you have universal service. And universal service does not exist in a purely market-driven environment. Let's look at a national example. The idea that you can pick up a telephone, get a dial tone in Key West, and reach Barrow, Alaska with 10 digits, the market would never provide that on its own. You could do a similar example here in New York. The idea that you could pick up a phone in some of the northern reaches of the state and easily dial Midtown Manhattan with 10 digits. This sort of point-to-point universality of service only happens in a regulated environment. And it's because the state maintained its carrier of last resort jurisdiction that the state was in a position to compel Verizon to rebuild in Fire Island after it attempted to degrade and substitute with the voice link product. So if we can talk about sort of the theoretical examples of a creeping regulatory state, and we can talk about whiteboard and economic theory, but then we can talk about the reality on the ground, which is that consumers need the reliability of point-to-point universal service, and regulators need to know that service will be point-to-point and universal if emergency response means anything at all.
Could I jump in?
Yeah, absolutely. If anybody else wants to respond, feel free.
Well, thank you. Just a quick point. So I think, at least the way it's phrased in the question, it seems like you might be putting the cart before the horse, because it seems before you can reassert jurisdiction, you defined a lack of effective competition. And so it might be better to, if that's the path that the commission wants to go down, to hold whatever hearings are necessary to get to that point, and then identify the specific problems that exist that constitute or contribute to what the commission perceives as lack of effective competition, and then tailor regulatory responses to meet those very specific needs. Because it sounds like that there might be already a framework in mind that would kind of blanket the industry, when in fact there might be very narrow problems that need to be addressed and could be addressed in much more or less intrusive ways. But I think also the assessment and lots of other data already highlights some of the problem areas. Getting back to the question about availability, there are challenges still out there to deploying networks, and we heard about this a lot yesterday from Ben from CTIA and others. When you think about where wireless isn't available in this state, it's usually in parks or densely areas where there are topographic challenges. A lot of those areas have very restrictive policies when it comes to infrastructure deployment, of where you can place a tower or an antenna. So those are areas that are ripe maybe for or even beyond the commission's purview to maybe even at the local level to address those, to facilitate deployment in these challenging areas. There might also be areas that are outside of those topographically challenging ones that have restrictive zoning ordinances. I know here in New York, for example, after Hurricane Sandy highlighted the fact that having your backup generators in the basement was not a good idea because they flooded. But zoning ordinances prevented the carriers from having their generators on top of buildings. I think that's changed since then, but that highlighted the problem that needed to be addressed. But that was also at the local level. So from a regulatory standpoint, I think if they're going in a very deliberate manner and identifying the challenges that need to be addressed and figuring out narrow solutions to those. But I would just say that having the commission make the determination that there's a lack of effective competition in the wireless space, I think would be a pretty shocking conclusion, even if it does go through the process of having hearings and gathering information. Because in the assessment, as well as even the FCC, which has declined to label the national market effectively competitive, but it hasn't said that it's not competitive or that's uncompetitive. In both the assessment and the federal wireless studies, there's a rich amount of data to show that there is, in fact, effective competition. But if there are instances, again, where there are narrow or specific challenges or issues that need to be addressed, then the better approach, arguably, is to target those rather than do a sort of blanket approach.
This issue obviously applies to the VoIP side of the house as well as the wireless side of the house. So my comments, I guess, are a little more addressed to the VoIP side. But I agree with Joe's comment about the potential for regulatory creep. But I think almost as importantly, the idea of regulatory uncertainty is very problematic. You've had two industries, the VoIP industry and the wireless industry, that have invested billions of dollars, and if I get repetitive from yesterday, I apologize in advance, billions of dollars based on a particular regulatory scheme at the state and federal level. Mike's paper on 706, which is excellent, and I commend it to everybody's reading, makes an interesting point actually in the context of 706 and the way the FCC decided to reinterpret 706. And one of the cautions was, particularly in a place where a lot of investment has been made in reliance upon a particular regulatory paradigm, regulators need to be very, very careful as they go forward. And then I think Michael, continued verbally about the fact that you have to be surgical, you have to have, I like his expression, a certain level of humility as you approach these issues, and the extent to which you don't know the future and you don't know how technology is going to evolve and you don't know how innovation is going to evolve, to make sure that you don't hinder those things. Because one of the things that we have seen in both of these industries is a lot of cross-pollination between different sectors in the industry, which you didn't have before. And so, aspects of the internet are dealing with aspects of the various wireline and wireless carriers, and both the innovation and also the cooperation in terms of responses to emergencies has really been stellar. So, I would caution that the commission look very carefully before it think about revisiting some of these issues that have just worked very well, especially with respect to, affordability. Affordability, I don't know how you address, quote, affordability without getting into some kind of price regulation. And both the uncertainty of regulation and certainly the cost of regulation, and all these things have costs. Add to the cost of investment, and uncertainty adds to the cost of investment. And we want folks to invest in this state.
Maureen, you touched on VoIP, and I'll turn to the second part of the question and stick with you for a minute. I think everybody up here is probably aware of the recent Minnesota decision to sort of almost reclassify VoIP service as a local service. Without getting into an opinion on it myself, I'll kind of ask the whole panel, if they could, to sort of give us their take on what Minnesota's done and if there is a legal basis for New York to follow suit at any point in the future.
I'm going to avoid the legal basis question. I think that this is an area which requires some federal guidance at least. The feds have, in their own regime, created a very lightened regulation approach to VoIP, and I think we should wait for some guidance before we as a state and regulators look at putting in 50 different constructs.
Anybody else?
Well, the Minnesota example is interesting. I mean, it's being challenged in court, so we'll have to see how that works itself out. If history is any guide, I think it kind of faces a steep climb, just based on as Maureen mentioned, there's been a federal kind of preference for regulating that service, and that goes back over a decade to cases that came up again in Minnesota and some other places, attempting to regulate nomadic VoIP. And those were preempted by the FCC and upheld in court. It'll be interesting to see if the federal court in Minnesota strikes down or overrules or finds contrary to the Minnesota Commission. I mean, what's interesting also is that other states have tried or have come to those conclusions. I think Maine and New Hampshire have as well, but then their state legislatures came and then removed jurisdiction from the public service commissions. And I think to date, over 30 states have passed legislation removing jurisdiction over VoIP services from PSCs expressly, and very few others have asserted or tried to assert jurisdiction. It's just been a handful of states. I think Vermont also is in the process. It's been a multi-year process of evaluating VoIP. I think they came to a factual determination that it was a telecom service, but they're still, that was the first part of the proceeding. Now in the second part of the proceeding, I believe that they are figuring out if there's a legal sort of basis for extending regulation to it. And I'm sure they'll look to the Minnesota case and some of the other precedent that has been set at the federal level and at the FCC when making that determination. But I think sort of just looking at the arc of regulatory and legal precedent in the VoIP space over the last dozen years or so, I think it tilts much further to the federal side, even if the FCC has had a docket open on the specific issue of whether VoIP is an IP information service or telecom service since 2004, still hasn't made a determination, but it kind of has reserved the right for itself to make that determination later, as well as to kind of dictate how the regulatory framework proceeds going forward, because they have preempted states in the past that have tried to regulate VoIP, but also they've also kind of layered on some additional, I guess, legacy requirements on VoIP, from contributing to the Federal Universal Service Fund to providing 911 service. So it's kind of carved out some requirements for VoIP on its own, while also reserving power, authority to itself for those kinds of issues.
I'd like the panel to address one narrow possible expansion of regulation to address a very specific problem, the digital divide. What does the panel think of asserting jurisdiction, assuming we get over issues like current federal preemption, over cellular and VoIP broadband services for the purposes of a state universal service fund that would provide subsidies for broadband service that would, of course, be portable into the industries that are paying into the fund?
As usual, Commissioner, you put us all right in the spotlight. Let me make a couple of comments with respect to that. First of all, there are a lot of programs out there, both private programs and public programs. Are you talking more about, line extension type issues, or getting computers in the classroom?
Actually, I'm talking about home broadband service.
So you're talking about getting lines into the home.
Or cellular broadband service.
Well, again,
I have something I can share. I think that it's clear that the state can be involved. California Public Utilities Commission has been very much a leader and an innovator in how to work within its own state lifeline framework. The state has seen fit to offer a top-up and a match to the federal 925, so then now the state level contribution is something on the order of $20. And as we know, lifeline modernization is moving forward at the federal level, it seems like next month. I think that there's a good model there to follow, that if the state should, in its wisdom, identify universal service and the digital divide as a problem, which it clearly is, that the state could move forward with repurposing its universal service funds.
well, I agree the state should move forward. And, we heard Jeff yesterday talk extensively about the broadband office program, which is, it's nothing to sneeze at. It's, $500 million that's going to be invested throughout the state. And just from my perspective, I think that's the appropriate place that should sit.
I think Maureen's hit upon a very important point. I don't think anyone here disputes that the digital divide is a serious social problem. I think it, to the extent it can be solved by money, the money should be raised on as broad a base as possible. It's a social problem, and it should be socially funded. I don't think that imposing the costs of that program narrowly on the telecommunications industry and its customers is necessarily the best approach. No one likes to talk about taxes, but I think the governor's broadband program is good not only because of its own merits, but because it introduces the model of public funding as opposed to industry funding for achieving these social objectives.
Just a quick additional point. So I think the question of Lifeline, state and federal, is a good one. I think the FCC is going to act, I think, next month to vote on its reforms of Lifeline and to extend it to broadband. I think is 925. So that'll certainly give the state some guidance and additional context for it. But from the perspective of funding a state-level Lifeline program, it kind of, I know it's separate from the State Universal Service Fund, right? So, but then it runs into the issue of whether the state can assess broadband providers for that purpose. In the FCC's open internet order, it makes a point of saying that the state commissions are bound by its forbearance regime. And as the sole example that they give is with respect to broadening state universal service funds. And the quote that the specific quote is that the imposition of state-level contributions on broadband ISPs that do not presently contribute would be inconsistent with the FCC's decision in the open internet context to forbear from mandatory federal USF contributions, and therefore it would preempt any state from imposing any new state USF contributions on broadband. So that's a consideration as well.
But we have to get past that.
Right, beyond, okay, so.
Assuming that the FCC in its reform of
Right.
its own Lifeline program allows the states to supplement
Okay.
the federal program with the same kind of contribution base, should we?
I see no reason why not to. And I think actually to the question of, so I think in a sense we have, I'll borrow your phrase, cart before the horse. I think there's an issue with the premise here, which is that, yes, everyone wants investment, everyone wants regulatory certainty, but I think the premise here should start from consumer certainty and the idea that that consumers will have advanced telecommunications services deployed in a reasonably timely fashion and that they'll have access to them on reasonably reliable terms, and they'll be able to purchase them in a reasonably affordable manner. And we should really be beginning our entire analysis from a consumer perspective, rather than would this overly inconvenience one provider or another, or might this unintentionally, theoretically help a class of providers over another class of providers? The job of the public interest the job of public interest regulation is to advance the public interest, not to advance the convenience of providers.
If I could, weigh in again, just to build on your point about consumers, and that's critically important because the Lifeline program is focused on consumers, getting more people online. But I'll go off on a policy tangent for a second, if that's okay. The notion, the Lifeline subsidy program at the federal level, state level, addresses an important issue because, as we know, there's lots of data out there showing that there's a big socioeconomic component of the digital divide. Mm-hmm. But I would argue, and we've done a lot of work on this at our program, looking at sort of the broad array of factors that go into broadband adoption. And it's a lot more than just cost. And I think Susan Crawford mentioned this yesterday, looking at things like relevance. And so, it's certainly within the toolbox of regulators to do things like Lifeline, sort of shift funds around and target them at newer services. But in New York, I think the governor has made a huge commitment to broadband, certainly. I mean, that's without question. But then the question is whether there are opportunities for using funding sort of across the board for sort of additional outreach, education, training, digital literacy, things like that, to make sure that more people see the relevance of broadband and getting online. Because Lifeline is not going to cover or solve this problem on its own. Not everyone's aware of Lifeline, not everyone is eligible, not everyone wants to go through the process of having to sign up for it. If someone sees that I have to do all this work just for $10 a month, they might not see the value of doing it. So if there are more sort of granular local level outreach efforts to get more people aware of the benefits of broadband, then that could drive either more Lifeline applications to the federal level, state level, both, or sort of organic broadband subscriptions on their own, seeing the value of investing scarce dollars on connection, and so long as they see the relevance and meaning and value to their lives. I think that's potentially something that the governor's broadband program could address maybe in the second round, maybe make some funds available for those sorts of programs, because I think it has to be kind of an all of the above approach to closing the divide, because this divide has been around ever since since the internet's been around. I mean, the contours are almost the same since the 90s. Socioeconomic components, the minority groups have been behind adoption levels since the 90s. Education levels differ when it comes to adoption rates. So we know the problems, so long story short, there are lots of other things that could be done beyond subsidies, and perhaps the Public Service Commission could highlight those. I don't know if it could actually do much on its own to address those, but highlighting the importance of those within the sort of package of things it does around the digital divide could be potentially powerful.
Actually, I have just one very short thing to say to the question of relevance. I don't think anyone is saying that we should not do digital inclusion or digital literacy at all. In New York, we have some really fantastic examples here. Tom Camber's OATS, Older Adult Technology Service, really is a national exemplar in how to teach digital literacy and digital relevance to older adults. And if you haven't ever had one of his seminars, sit down with him. It's amazing. However, I think, as putting on my social scientist cap, there are a couple of problems with the way that the surveys that say that relevance is one of the chief barriers. One, lower income people are more likely, this is me just being critiquing the research here, there is shame in saying I am poor and can't afford that. It is a lot easier, and socially, there is stigma attached there. It's easier to say, that's not relevant to me, I don't need it. Second, to the extent that relevance is an issue, changing the cost structure and introducing a subsidy changes the cost-benefit analysis. The entire relevance calculation then shifts when we've got a different numerator and a different denominator. So I think while we absolutely should be investing and finding ways to teach digital literacy and digital inclusion, I think the mayor here in New York is doing some really exciting work in that area as well. I think Susan Crawford is a great friend, but I think sometimes we use the word relevance without really digging into what does it mean. And I think there's maybe some problems on a social scientific standpoint with the research that says that relevance is the chief issue. I think it's superficial and doesn't get to the heart of the matter.
So I think we'll come back to some of the broadband issues later in the day.
Can I just add one thing, Graham?
Sure, Joe.
I think the discussion of adoption and relevance is very interesting. I take your point in that it is indeed an interesting one that probably hasn't been considered enough. But I'd like to use relevance as a jumping off point for considering other non-traditional approaches that probably don't receive as much consideration as they should for expanding broadband deployment. One tremendous problem that providers face is access to public and private rights-of-way. And although this may not be a role particularly for the commission, it's certainly a role for the state in easing the current barriers that make it difficult for providers to build facilities, particularly in some of the underserved areas of the state. and I'm referring here not only to public rights of way, but to issues relating to private rights of way, particularly in a multiple dwelling unit environment as well. Another area that should be thought of, again, not particularly in the commission context, but certainly by the state, is tax policy and its impact, both depressing and stimulatory to investment. I won't go into this in detail here. It's probably a subject for a whole nother forum. But there are a number of steps that the state could take to increase incentives for broadband investment.
So I think at this point, it's not a great transition, but we'll turn to our next question. We heard a lot yesterday about the IP transition and how IP providers, whether fixed or nomadic, have really exploded in terms of consumer adoption. So I know there's a question close to Commissioner Sayers' heart. So we wanted to touch on whether and how the PSC could oversee the filing and adoptability of IP-to-IP interconnection agreements. The FCC has seemingly, at least, allowed a state role under Section 252 of the Telecommunications Act. So I think we'll stick, Joe, with you to touch on this if you'd like.
Thank you, Graham. As a starting point, when I was reading over these questions last night, it occurred to me there was an ambiguity, and my understanding is that what we're talking about here is interconnection for purposes of exchanging VoIP traffic, as opposed to peering and transiting arrangements for internet access traffic. Yes. Yeah, okay. Glad to hear it, because that's what I'm prepared to.
Or even POTS that's been translated within the network.
Right. So my view of this as a legal matter is that exchanges of voice traffic in IP format are not subject to either the substantive obligations of Section 251 of the Act or the negotiation procedures of Section 252. This is another one of those issues that the FCC has under review. To my knowledge, it's never interpreted the incumbent interconnection obligations of 251C2 either to allow a carrier to demand IP-to-IP interconnection or to require interconnection for the exchange of traffic that never touches the public switch telephone network. In fact, the FCC recently confirmed in an appellate brief that it had not yet taken action in this area. Last year, it declined to mandate VoIP interconnection arrangements because, quote, the Commission, meaning the FCC, is currently considering the appropriate policy framework for VoIP interconnection in pending proceedings, close quote. I won't pretend the FCC has preempted this area, but I think cooperative federalism works in both directions, and I think this is an appropriate area for state forbearance while we're waiting for the FCC to set a national policy in this area, which is clearly on its current agenda. Look, the 252 process for negotiating interconnection agreements was created in a very different environment. Now, ILECs are just one of the many players in the marketplace. They have no special historic advantages in the provision of VoIP service. I don't have the figures with me, but I'd be very surprised if in New York as elsewhere, the ILEC share of the VoIP market is far smaller than the cable company share. Under these circumstances, I think that, at a minimum, states should await guidance from the FCC. More importantly, and I know I'm beginning to sound like a broken record on this point, I think it'd be bad policy. I think that commercial negotiations are a good mechanism for achieving IP-to-IP interconnection. The internet ecosystem has flourished under a regime of negotiated commercial traffic exchange arrangements, and I think the same is true, could be true in the VoIP area. government should really avoid prescribing the terms that will govern complex and evolving relationships among different providers. And there's always the factor that state regulation is going to impose a crazy quilt of disparate regulations on what in most cases are nationwide or in any event multi-state arrangements. My clients, the Verizon companies, have been industry leaders in negotiating IP and IP interconnection agreements. We've entered into them with partners of different sizes and types. Some providers are, in our view, are not serious about negotiating agreements with us. Others appear to be uninterested in establishing IP to IP interconnection arrangements. But from my seat, the commercial agreement mechanism is working, and as yet, there's no reason for intervention, certainly state intervention in the process.
I only very cautiously and rarely disagree with Joe, especially about the law.
And that's wise, Marie.
But we do feel that 251C does allow for state involvement in this issue. We do acknowledge and appreciate the fact that the FCC does have an open docket on this, and we are watching it very carefully and participating in it carefully. But I would also like to distinguish these kinds of regulations versus the other kinds of things that we've been talking about this morning. I felt very strongly for a long time that the states and the feds, but the states can play a very important role in wholesale issues and business-to-business issues. And again, and we've even seen this evolve on the regular voice interconnection front. Most of the time, it is just company to company. But to have the commission there as a backstop to be of assistance and to help negotiate, I think is very helpful to businesses. So, again, we are also watching what happens at the federal level on this issue, but we are hopeful that the states will play a role in this.
So we're lucky enough to have we're going to go off panel for just a second, but Joe Geduldig is here today, and has a lot of expertise in this particular area, so we're going to ask him for his comments on this topic as well.
I have to use the lounge singer. He went off. See, we've already had an interconnection problem. As indicated, my name is Joe Geduldig. I'm an economist, been working in the area of telecom policy, technology, state issues for, unfortunately, about 30 years. I have specifically been working on issues relating to what happens when the network goes from a TDM technology to an IP technology in terms of making sure the competitive opportunities and network interoperability continue. So I probably have the longest running involvement with IP to IP interconnection of anyone in the country. I measure my success in small increments. Now, first I want to make a comment about your program that'll tie into this. There are three markets in the telecommunications industry. There's the residential market, there's the market of business services, and there's the wholesale market. And I put quotes around the word wholesale market because it really doesn't exist at all. But there are a set of wholesale issues that would otherwise be market issues if there's any true competition creating that. Your program has been excellent, but one thing I need to point out is that with very rare exception, this entire discussion over the past day and a half has focused on the residential marketplace. If you were to, this is not the conversation you would have if you were asking the same questions you were asking, but the panel was focused on what are the conditions in the market for business services. That looks very, very different, okay? And I'm not going to go into those differences. I just want to make that point that you have been, like many of these programs, sort of sucked into the black hole of the residential marketplace and all the issues unique to that. And this is the only thing that you've sort of broken out to talk about at least the wholesale market. Now, on the question of interconnection. The 96 Act embodied in it a really critical principle, and that principle was competitors had rights with incumbents in terms of interconnecting and exchanging traffic. They were going to be co-carriers to the incumbent, not customers of the incumbent. And those co-carriers had rights to be treated as equals, even if they were vastly different in size. So when you really lay out this issue, what you discover is that by and large, it's not a question between competitors and ILECs. It's really a question of between people who are small relative to the incumbent and everyone and the incumbent. And so you oddly find in this issue that CLECs and rural telephone companies and small independent telephone companies and virtually all cable companies all line up on the view that the 251-250 structure, 252 structure does not disappear merely because the calls are going to IP. Now, why is that so important? Well, there's really two reasons. One is a fear of discrimination. If you let discrimination creep into interconnection so that big players can get better traffic exchange agreements than small carriers, you are going to create the seeds for unrelenting concentration. And as a practical matter, one of the things I heard over the past couple of days is people aren't generally satisfied with the degree of concentration that exists already. My God, why would you promote additional concentration? Secondly, not only do you have this discrimination protection, which, by the way, is fundamentally protected by the fact that the contracts have to be made public, and the state commission's role isn't to hamper negotiation. It's just to make sure that the contract, when it's filed and is public, other parties have an opportunity to say, hey, that's discriminatory, or this provision's not in the public interest. But it's a transparency role that the state commission plays with a second critical component, and that's opt-in, all right? The Telecom Act gives you the opportunity not to sit down in a dark room knowing none of the other deals that Verizon or some incumbent has cut with other players, but you actually get, before you go to the negotiating room, you get to look at the contracts that already exist and say, yep, I can live with that. I want it. I want to opt in. And when you look at this industry, 90% of the agreements in every state I've ever been in or any process I've been involved in are opt-in. The foundation of this industry isn't arbitration and conflict, it is opt-in. Let me have that contract, and then I will conform my business to its requirements, and I will move on. So we have this system, 251, 252, that is designed to prevent discrimination and give you opt-in. Now, what do those agreements really look like? The FCC has been very clear in providing guidance. It just says, look, if these agreements address, and there's a list, I don't have all of them memorized, a list of duties or activities. If they involve resale, if they involve number portability, if they involve reciprocal compensation, if they involve interconnection, then these are interconnection agreements under the Act, and they have to be filed. I will tell you, contracts don't hide what they're about. So if you get to look at a contract, you can pretty easily see, does it address these activities? And who is it that's supposed to decide whether they have to be filed or not? It is not the incumbent. It is not Verizon. The law is quite clear. The FCC orders are quite clear. It is the state commission. To the extent there's any dispute about whether something should be filed, the state commission, not the FCC. The FCC expressly states in an order called the Quest Declaratory Ruling, the entity of first review on this question of whether something should be filed is the state commission, because the state commission is closer to the process of being able to review the contract. Now, why is this such a big deal, and where are we? The reason it's such a big deal is Verizon has been a leader. And yeah, they got a half dozen or dozen contracts. This all comes out, quite honestly, of a California proceeding. But there are two that are the most critical that people want to see and be made public so they can determine whether to opt in. Verizon reached an agreement with Comcast at around the same time that Verizon and Comcast were agreeing to do joint marketing of their services. It wasn't really arrived at in an adversarial tone. Secondly, Verizon has a contract with Verizon Business, its own affiliate. Other carriers want to know, what do those agreements look like, and can I opt into them? In terms of state authority, by the way, Michael pointed out that there's about 30 states that have removed VoIP jurisdiction. In each and every one of those laws that I've seen, and I will admit, I have not seen all 30, but I've only probably missed one or two. Every single one of them I've ever seen always has a reservation clause in it that says, we are removing from the commission authority over VoIP, except the commission still has authority to fully do its duties under 251, 252. So there's never been a question as to whether or not states had the continuing authority to look at these just because they went to IP. Now, where has the FCC left it? The FCC left it where they said unambiguously that all VoIP calls are subject to 251, 252 as a call, because they brought VoIP to PSTN, PSTN to VoIP, and VoIP to VoIP calls into its inter-carrier compensation order, into section 2, into the provisions of the reciprocal compensation. Now, they left a hanging chad. They said, we're making this decision for everything that's where it's exchanged in TDM, but we're going to keep looking at it for IP. All right, but think about this for a minute. If the calls are subject to the Act, and the only thing that changes is that you exchange the traffic and IP instead of TDM, which if done correctly should be completely transparent to the customer. There's no way to cobble together an argument that says that this one little event, I exchanged the traffic and IP instead of TDM, somehow changed the nature of the call, when the FCC has already made the tough decision, which is the call itself is subject to the Act. Why did the FCC leave a hanging chad? I will come to that last. If anyone wants to know, you have to ask me, because it'll take me a little off a point, because I want to come back to these two contracts. These two contracts are being transferred from Verizon to Frontier as part of the California merger. We finally had a break in the wall of confidentiality, because the California Commission ruled, hey, before the contracts can be transferred to Frontier, they got to be filed. So we expect them to be filed under 252 in California Friday, maybe Monday, unless there's some super game about to be unfolded, which I don't expect. Once they're public, it'll be much easier for state commissions to answer this question, because again, contracts don't hide what they're about. You'll be able to look at it, you'll be able to determine if it applies in your state, you'll be able to determine whether it addresses things like number portability, reciprocal compensation, and interconnection. And you'll be in a position to do your duty under the Act that the FCC gave you to tell Verizon, hey, file this. Why? Because competitors actually want the same thing Verizon wants, which is not a patchwork quilt. Competitors want the opportunity to see what deal did these two carriers get and whether they can opt in. Because if it's discriminatory, you've got a world of problems about to descend on you. If this whole industry moves over to IP and the core wholesale protection of non-discriminatory interconnection gets lost in the shuffle. It's not something that you want to lose. And that's what I go back to in terms of, you got three markets here: wholesale, business, residential. You should actually have one of these programs on business and wholesale. Completely different speakers, completely different problems. You'd hear a lot more about last mile access, because the people who are competing in the business market require it. But in terms of this one question, you have a clear duty, you have a clear problem. There are contracts that Verizon signed with friendly entities that carriers would like to have opportunity to at least opt into. And fortunately, they're about to become public so that this conversation can deal with hard facts.
Listening to your presentation, amazed to contemplate the fact that 99.9% of the American economy, vertical and horizontal arrangements between producers, are not publicly filed, are not governed by substantive obligations, anything remotely like those of 251. In fact, I can only think of one example that even comes close to that regime, and that's the liquor industry, which obviously has social and historical components that telecommunications doesn't have. So why is telecommunications special? Why was this regime established in 1996? Well, I mean, I don't think there's any doubt what the answer to that is. It was in recognition of what was perceived to be the special market position of the incumbents. I heard words during your presentation like big, large, concentration, market power. I don't think we need to debate here whether those were appropriate in the TDM market as applied to what we now call incumbent lex. I do dispute, though, that regime has any policy relevance, and I would say any legal relevance, to the position of incumbents and their competitors with respect to the exchange of VoIP traffic. As I said, we're hardly a dominant player, and actually rather far smaller player than most market participants in the VoIP market. So the idea that somehow vertical agreements can't be negotiated, but with a 252 type mechanism in place, because otherwise God knows what parade of horribles will follow, it just can't be sustained. That's the policy argument. On the legal argument, I really didn't hear you disputing that the FCC hasn't decided this issue. You indicated that you have a theory about why it hasn't decided it, and you indicate you thought it should have decided it and that it will decide it in a certain way. But the issue is up in the air, and I think my comments about cooperative federalism are still germane. We could spend the rest of this forum and a whole nother one arguing about the details of 251 and 252, but I think it probably is appropriate in a forum like this to focus on the policy issues, and to my mind, they point more in the direction of abstention than of active regulation and trying to extend the 252 regime into an area where it's very ill-suited.
The 252 regime has already been extended, and it was extended, quite honestly, at the urging of large carriers like AT&T and Verizon, who wanted to get rid of reciprocal compensation and access charge obligations relating to the termination of their traffic. And so the FCC, in the inter-carrier compensation order, did what the large carriers asked and brought all VoIP to PSTN, all PSTN to VoIP, and all VoIP to VoIP traffic into an inter-carrier compensation regime that meant everybody had to step down towards bill and keep, okay? And that whole regime was designed to basically benefit carriers that had large terminating volumes at the high end of the market, which was basically AT&T, Verizon. The collateral beneficiaries were Sprint and T-Mobile, and the people who ended up having balance sheet or income statement issues from the decision were cable companies, CLECs, small ILECs, and other people that were opposed to it. But it happened, okay? And it happened to bring that traffic in. Now the question only is, in this one little area about what technology is used to swap the call, should that somehow excuse carriers out of that entire regime, which, as a basic matter, fundamentally is requiring disclosure and opt-in rights as the key
I don't think
discrimination
interconnection
protections.
is a subset of inter-carrier compensation. Inter-carrier compensation, that 900 paragraph or whatever it was.
956.
956, thank you. It was very deeply rooted in very specific history and policy factors and economic factors of inter-carrier compensation. They don't necessarily provide guidance on the very separate issue of interconnection, and the FCC itself indicated that for reasons that you apparently believe are inadequate.
No,
but
no, no, that's
the-
actually not true. I mean, interconnection is just the linking of two networks and is a physical
It involves
event.
physical
Hold on a second.
arrangements.
The movement of traffic across that interconnection is reciprocal compensation. You cannot address reciprocal compensation without also affecting interconnection because you have to link the network for the traffic to flow across in both ways. All right? Now that's,
That doesn't
that
seem to me
order
a cogent
did
conclusion
already
to
take
me.
the step that you want, that you have a policy argument against, but Verizon didn't argue that policy argument very vociferously when it forced everyone's prices towards bill and keep, where fundamentally you were one of the beneficiaries of that. This is also not just, quite honestly, an ILEC obligation. It's also useful to note that the FCC put the wireless industry under this system too, for if, in fact, an incumbent ILEC was having difficulty negotiating an interconnection agreement with a wireless carrier in the T-Mobile decision, the FCC said that ILECs could use the 251-252 process to gain interconnection and traffic exchange contracts with wireless carriers. So the FCC has been, the system is what the system is. I will agree the FCC left this hanging chad. I will also say that the only reason it left that hanging chad is it was because it was trying to move an order through on inter-carrier comp and all the USF. I mean, that 956, well, I'm 80% certain that's the number, but I could be off.
Are you counting the Paperwork Reduction Act there?
No. The Paperwork Reduction Act section that is the same in every FCC order. That was part of a giant deal, or a giant proposal, I won't use the word deal, crafted by the largest ILECs and some mid-sized ILECs to take care of some inter-carrier compensation issues and to create a new universal service system, okay? This didn't get resolved because the FCC at the time could not add another issue into the pot. Is this issue going to be resolved by the FCC? Not anytime soon. It's not on their agenda. Yeah, they got an open docket. So what? They ain't moving it. This administration has 10 months left, and they don't need to move it. They're well aware of the fact that these contracts are now going to be filed in California. They're well aware of the fact that the states can resolve this, and they're not going to, and there's no indication that they've ever given that they ever intend to lift a finger to change any of this. The contracts will, thank God, get filed, unless something really weird happens, they'll be filed very soon. They'll be public. And states where they're applicable will have to make a decision. Are we going to walk away from our responsibility? Because it's your responsibility under the Quest declaratory ruling to make the decision as to whether these should be filed as interconnection agreements. And the standard is pretty clear.
I think that's as good a place to leave it for the moment as any. I think what we've learned is that maybe we should look at having a wider conversation about some of these wholesale issues. Right now, I think we're going to take a 15-minute break until, let's call it 11 o'clock, and then we'll come back and talk about some of the broadband issues surrounding the Open Internet Order and Section 706 of the Telecommunications Act.
706, my favorite.